and welcome to all those listening into the program. As an introduction to today's program, I'd like to start off with a brief overview of crowdfunding before we get into a discussion of each specific type of crowdfunding. This should help you to better understand the different types of crowdfunding that Shane, Linda, and I will discuss, and whether crowdfunding would be an effective capital raising approach for you under your specific circumstances. And you know, crowdfunding is certainly a popular topic right now, especially since federal crowdfunding just became effective this past Monday, 2 days ago. But it can also be a very confusing topic because the term crowdfunding is used to mean a number of very different types of fundraising and capital raising activities. So we'll explain the basics of crowdfunding, help you look through the confusing publicity about crowdfunding, and hopefully help you gain a better understanding of whether crowdfunding is right for you. So crowdfunding is certainly a viable option for you to consider for raising capital, but it's not necessarily your first choice. There are a number of different ways to raise capital, and most all of which have been covered in these prior webinars that Linda mentioned. Each of these different methods to raise capital has its pros and cons, so you need to discuss your situation with a knowledgeable attorney to decide which type of capital raise meets your particular circumstances and needs. So we'll try to put crowdfunding in perspective and suggest some practical circumstances where it might be an effective way for you to raise capital. Now, I can't see the screen. I can't see the slides on my...
For some reason, it is just darkened, and we are fixing that immediately.
Okay. Well, I'll just continue on, and then hopefully...
Thank you.
You'll bring that up. So I'm currently on slide 2.
I'm sorry, Rick.
Yes.
I'm going to have to close the session. It may close the whole session. If that happens, all the participants also, please hold on. If it kicks you out, please log back in. Thank you.
So I guess I'll continue to talk, and if for some reason I lose you, let me know. So
if we wait just a moment, this is our first one we've had any technical difficulties on. I'd really like to make sure we have everybody watch this presentation. If we could hold on for just 1 minute,
okay,
that would be great. Thank you so much for your patience. We're still working on it. Give us just another minute.
Okay, Rick, go ahead and go up to the side you need, and everything should be okay. Thank you.
Okay, here we go. All right, sorry, everyone. So let's just talk about the basics of crowdfunding. So what is crowdfunding anyway? Crowdfunding is simply a large number of people, the crowd, you know, pooling together small individual contributions or investments to support a particular project, cause, or business, and typically this is done over the Internet. The main advantage of crowdfunding is that it allows you to reach an unlimited number of potential investors, again, the crowd, through the Internet and social media. Another advantage of crowdfunding is that it generally allows anyone to invest in the company making a crowdfunding offering. And as I said, crowdfunding can be very confusing because the term is used to describe several different kinds of fundraising and capital raising efforts. So there are two main categories or buckets, if you will, of crowdfunding. First is donation crowdfunding, which has been around for years. Essentially, this is just interested persons donating money for a cause or project. In some instances, you might buy a token product or get a token service, which we call rewards crowdfunding, but it's really just a different form of donation crowdfunding. Kickstarter and GoFundMe, which you are all probably familiar with, these are the two major websites for donation crowdfunding. Donation crowdfunding is not subject to securities laws because there's no security involved. You're not buying an interest in a company and you're not lending any money. You're just donating your money to support whatever project or cause you support. The second category is investment crowdfunding, which is subject to securities laws. That's because in investment crowdfunding, you're either buying an ownership stake, equity, in the company, or you're loaning money to the company that will be repaid with interest, or in some instances as a percentage of revenue. Now, investment crowdfunding is new and was not available prior to September of 2013. Most all the buzz you've been reading about crowdfunding relates to investment crowdfunding because it's new, although it often gets mixed together and confused with donation crowdfunding. But donation crowdfunding and investment crowdfunding are two very different ways to raise money because investment crowdfunding is subject to the securities laws and donation crowdfunding is not. Yet another type of securities offering that is sometimes called registered crowdfunding is the Regulation A+, which Linda mentioned at the beginning and which was covered in a different program. So we're not going to talk about Regulation A+ in this program. It's really more of a mini registered offering or a mini IPO. And so we're not going to talk about Regulation A+, and we're not going to talk about donation crowdfunding in this program. And there's no particular legal limitations on donation crowdfunding. And in most cases for-profit businesses, donation crowdfunding is really not very practical. So we're going to focus on investment crowdfunding, and we'll talk specifically about three different types of investment crowdfunding, namely federal crowdfunding, Michigan intrastate crowdfunding, and what we call accredited investor crowdfunding. So in order to evaluate whether any of these options are right for you, you really need to understand all three forms of crowdfunding that are available in Michigan. So now let's briefly discuss the regulatory background for investment crowdfunding. This will give you a better understanding of how investment crowdfunding is different and why Michigan crowdfunding specifically was adopted. First, understand that the primary rule in selling any security is that the capital raise has to be registered with the Securities and Exchange Commission, the SEC, or you have to find an exemption from such registration that applies to your offering. And as most of you probably are familiar, these exempt securities offerings are called private offerings or private placements, and they're typically using exemptions under SEC Regulation B, which again was covered in the prior program that Linda mentioned. The Jobs Act, which was adopted 4 years ago, expanded these exemptions from SEC registration. And one of the key provisions of the Jobs Act was to permit, in certain circumstances, general solicitation and advertising, now think the Internet and social media, to raise capital without having to go through this complicated registration process with the SEC. Prior to the Jobs Act, general solicitation and advertising were not permitted in private offerings. So federal crowdfunding is the main method through which the Jobs Act permits you to raise capital through the Internet and social media. But it's taken the SEC forever to adopt final rules that govern federal crowdfunding. The proposed rules were issued 2 years ago, and they weren't finalized until October, and federal crowdfunding was not effective until 2 days ago, this past Monday. So this delay in the SEC adopting final rules to permit federal crowdfunding has resulted in more than half of all states adopting their own state-specific crowdfunding rules. Michigan adopted its crowdfunding law in December of 2013, and there's lots of other state crowdfunding legislation pending in other states. Now, the major limitation of these state crowdfunding laws, which Shane will discuss in more detail in a moment, has been that the capital raise can be offered and sold only to residents of each specific state. If you offer to anyone in another state, it violates the securities laws and is not valid offering. So this prohibition on making offers to residents in another state has limited the use of state crowdfunding and can be an easy mistake to make that can invalidate your state offering. This all relates back to an SEC Rule 147 that was adopted way back in 1974. As we all know, the SEC didn't have the internet or crowdfunding in mind when they adopted this rule back then. So the SEC has recognized that this rule is limiting the use of state crowdfunding, and so just this past October, they proposed changes to Rule 147 that would only require that sales and not offers would need to be to in-state residents. And Shane, again, will talk about this more in just a moment. But the main point here is that this would open up the opportunity for general solicitation on the Internet for state crowdfunding, which would make it easier to take advantage of state crowdfunding. Any sale would still need to be made only to in-state residents. So although this avoids some inadvertent missteps under Rule 147 for state crowdfunding, it still doesn't change the fact that under state crowdfunding you're limited to selling only to in-state residents. Federal crowdfunding does not have these limitations. So you can solicit investors in any state, and you can sell to investors in any state. And now that federal crowdfunding is available, it'll be curious to find out if it'll limit the use of state crowdfunding, because basically it allows you to sell to a broader crowd. But again, the circumstances where state crowdfunding might be the best option for you still tend to be for businesses which may have a particular focus or market on a local community level. Now also note real quickly that even though investment crowdfunding allows general solicitation and advertising, any crowdfunding offering is still subject to the anti-fraud prohibitions under federal and state law and civil liability. So any advertising and disclosures you make still have to be accurate and not misleading. So so what's new quickly about crowdfunding and what's all this fuss about? First, as we said, prior to 2013, a business could not use the Internet or social media in a private offering. You had to register with the SEC. This has all changed with the Jobs Act. The second key point is that most such private capital raises in the past were limited to accredited investors, which had to have a certain level of income. In true crowdfunding, which is federal and state crowdfunding, anyone can invest. In accredited investor crowdfunding, only accredited investors can invest. The idea behind true crowdfunding is to allow anyone to invest in developing companies, sort of get on the ground level of the next Apple or the next Google. But this often gets overemphasized because you have to balance the objective of allowing anyone to invest with the need for investor protection, because these crowdfunding offerings tend to be more risky and provide opportunities for fraud. So as I mentioned, there are three different ways that you can do an investment crowdfunding in Michigan. There's the federal crowdfunding, the Michigan crowdfunding, and accredited investor crowdfunding. So what is an accredited investor? Real quickly, these are investors that have sufficient financial resources and knowledge to be able to assess the risks of a private placement. The different levels are there on the screen. It's individual income in excess of $200,000 in the last 2 years, or joint income with a spouse in excess of $300,000. Also, if you have net worth of $1 million, not including your residence, and then directors and officers of the issuer and certain entities with $5 million in assets. So to help you understand the difference between these three forms of investment crowdfunding, there's a chart at the back of these slides. Slides 22 or 21 and 22 if you have the copy, and this will be a guide we'll go through in just a minute. Crowdfunding, now that it's fully available, is still likely not your first choice. You would typically not look to crowdfunding until other sources through friends and family and banks and other private placements are available. It's now available, so it'll be a avenue that others can take advantage of. So with that, I will turn it over to Shane to discuss federal crowdfunding and Michigan crowdfunding in more detail.
Great, Rick, thanks. And I'll just add to your comment about the various methods and pros and cons here briefly to say that one of the reasons that crowdfunding may or may not be as attractive is because of the lack of confidentiality. It's obviously based on social media. It is a very public process. and there's basically no ability to get a confidentiality agreement, and the company that's seeking to raise the money is going to have to disclose its basically on the internet, on the crowdfunding website, it's going to have to disclose its business, its plans, its use of proceeds. And so protection of intellectual property, if it's important to the business, is really going to be critical to having patents, trademarks, copyrights that can help protect it. In the absence of that, if you're simply going to have an idea that is to be first to the marketplace, crowdfunding is probably not a good way to do it, because the marketplace will know what it is that you're proposing to do. And I might add that you can't control who your investors are, and it's very possible you could end up having a competitor owning and receiving information from you going forward. And in addition, you may have many, many small investors, all of whom know where you work, maybe where you live, and when issues arise, they know where and to whom to call. And so it is a drawback to the method used on a crowdfunding platform. Now, if the slide turns here, I think it will momentarily, let me talk a little bit more about federal crowdfunding. And let's see if this will make it work. There we go. So in federal crowdfunding, the basic requirements and limitations are that this exemption from SEC registration of your offering and this method of raising capital is limited to private companies here in the U.S. It limits on an annual basis the amount of money that can be raised by a company, also called an issuer of the securities, limits it to $1 million in any 12-month period. And then, in addition, there are limits on the amount of investments that can be sold to investors. And as Rick said, really the purpose of this limitation is to balance the need for economic development to raise capital with, at the same time, investor protection. So the threshold, as Rick said, is basically open to anyone making an investment in crowdfunding, and so the protection is basically to limit the amount of risk of loss that a prospective investor might incur. So from the investor side, all crowdfunded investments for an investor in any 12-month period are limited to either of two thresholds based on the investor's financial circumstances. So the lower of the threshold is a maximum of $2,000 or 5% of the investor's annual income or net worth if it's less than $100,000. If that individual investor has an income or net worth greater than $100,000, the limit goes up to 10% of the investor's annual income or net worth. And I might add that this is not limited to natural persons. The same thresholds would apply if it were an entity, such as a limited liability company. You would look at the financials of the entity. As Rick said, importantly, the use of crowdfunding requires that there be an intermediary. It's really based on social media. So the basis for the exemption requires that the transaction be conducted through either a registered broker-dealer, that is to say a firm that's registered with the SEC and a member of FINRA and registered in the states where the offering is made, or the new wrinkle here with crowdfunding is the creation and regulation of what are called funding portals. and I'll talk a little bit more about that in a moment. Importantly, there are limitations on advertising. You do get on the portal, on the website, to, of course, have your offering advertised. But outside of that, you're only permitted to basically have a notice that directs investors to the portal or to a broker-dealer, and you can't do general advertising beyond that. There are also information and filing requirements that go along with the crowdfunding exemption. And we're a little slow on the page turn here. There we go. Importantly, crowdfunding really depends on the portal, the intermediary, and it is basically an electronic platform. The platform, the portal, cannot offer investment advice, cannot make recommendations, and cannot hold funds or securities. It's essentially a display-only feature so that people can see it by logging in, and cannot be used to solicit purchases or sales. It basically is a display case, if you will, to put these offerings in front of the crowd to look at. The portals are not permitted to pay transaction-based compensation to its employees or agents. That is to say, it can't pay commissions. It's essentially a service, and as long as it limits itself to those activities, it is exempt from federal and state broker-dealer regulation. But that said, the portal is still itself required to be regulated and registered with the SEC and FINRA because it does play an important role in these transactions. And so the portal is registered with both the SEC and FINRA. The portals are required to provide disclosures on the websites and educational materials and take steps to help mitigate the risk of fraud. And I think in practice, as Rick said, this has only just become effective this past Monday, and so there has not yet been any real experience with this under federal crowdfunding. But I would expect that the portals would be basically set up to screen prospective investors' investment limitations. That is, as I mentioned, the limitations based on the annual income or net worth. I might add as well that the portals are not permitted to give legal advice, and so as a result of that, firms that plan to do private offerings need to get good guidance about structuring their business and the legal aspects of raising capital, because they won't get that kind of advice from the funding portal. Let me just ask our host, there we go, was not seeing the page advance. So here is a list of the current crowdfunding portals that you can find that are FINRA, which is the Financial Industry Regulatory Authority. These are FINRA-registered funding portals. There are currently only 8 of them. The link there on the screen can be checked periodically to find the current list. Beyond the names that you see here, the website itself also includes addresses and contact information. And these are not yet common household names, but as the concept of crowdfunding moves forward, maybe they will become more like Kickstarter and GoFundMe kinds of names that people recognize. So switching then to the issuers, that is to say the companies that are making offerings of their securities to to the public on a crowdfunding website. They are required to file what is called Form C, C for crowdfunding, with the SEC, and it includes not only a form that has some form-fillable text boxes that the SEC uses to gather information, but also an attachment that includes minimum prescribed disclosure information. The information includes who your officers, directors, and 20% owners are, information about the business and the intended use of proceeds, the offering price or a method for determining the price, a target offering amount, and a deadline that it is to be reached by, which is important so that offerings don't continue and drag on for an indeterminate length of time. In addition, it needs to indicate whether investments in excess of the target will be accepted. So if it's an idea that the crowd is wildly crazy about and gets lots and lots of investors, the question is the issuer going to continue to accept funds in excess of the target? And it's important there to know whether or not the use of proceeds, basically if they have too much, if they're so lucky to have too much proceeds, how that money would be used if it's in excess of what the target is. In addition, disclosures need to address related party transactions. That is to say, if there are affiliated companies or relationships with people connected to the company, are there conflicts of interest and expenditures that would be used that investors should know about. And then, in addition, information about the issuer's financial condition and their financial statements, and I'll say more about that on the next slide. The Form C includes these text fillable boxes. The SEC uses this to collect data, and as I said, the particular format for the presentation is not prescribed. So if the presentation here will advance, we'll go to the next slide. There we go. Not yet there. Apologies. Now it's appearing. There we go. So as to the financial information that is required, it really breaks down into three categories. So for the company that's seeking to raise the money, it's based on the amount of investments that are offered and sold within the preceding 12-month period. So the first bucket is if the company is seeking to raise or has raised $100,000 or less. There are financial statements required, but not an obligation that they be either reviewed or audited by a CPA, only that they be certified by the chief executive officer. And in addition, certain federal tax information would also be required. Alternatively, if available, CPA-reviewed or audited financial statements can be used instead of having to provide CEO-certified tax information and financial statements. The next bucket is from $100,000 and $1 to $500,000, and there is a requirement that the financial statements that are presented on the crowdfunding website and filed with the SEC on Form C or with Form C be reviewed by an independent CPA. And if available, audited financial statements may be used. And just a footnote here, for CPA reviewed and audited statements, there are essentially three levels of CPA service. There are compiled financial statements. That is insufficient for this purpose. The next level up is reviewed, where the CPA will review the statements and perform certain procedures to provide some assurance of the accuracy. And then at the top level is a full-blown audit. And so the good thing here is that the SEC has allowed for lesser levels of CPA attestations, and basically allowing it at a lower cost. The third level, at $500,000 or more than $500,000 for first-time issuers, there probably aren't financial statements that would be audited if you're a startup, but they do require that if you have financial statements, have been operating, that they be CPA reviewed, and again, if available, audited. But that's for first time only. For subsequent offerings, that is to say, if you did it a second year or did a second offering, then you would have to have audited financial statements by the CPA. So, next slide coming up. There are some additional requirements for issuers. Most importantly, amendments. And this is actually an important point to make, that you really want to have at the outset of your offering, when it's basically put up on the platform and available for prospective investors, you want to have pretty well figured out what it is you're going to do, how you're going to do it, because if you change it, if you want to make a material amendment to your offering, then you're going to be required to basically go back to each investor who has already subscribed within 5 business days, or if not reconfirmed, the investor's commitment is going to be canceled. Now that seems perhaps really hard, though I think on an electronic website, if the web platform is set up, likely it will end up giving an email notification to alert the investor that there's something that requires attention and to reconfirm. How that works will depend on the website, but in terms of the exemption itself, the requirement will be that if there's a material amendment to the information that has been presented, the issuer will have to go back to get confirmation or reconfirmation of the investor's commitment. In addition, there are progress updates required that have to be filed with the SEC and provided to investors and the website. There are 3 basic points in time: when you reach 50% of the target, when you reach 100% of a target, and when you reach the deadline for the offering. These are designed to keep investors apprised of the status of the offering. It's also useful for the SEC and the website to understand, and I think we can expect websites to monitor this in how they're set up. In addition, annual reports are going to be required. The SEC has what's called Form C-AR, that's annual report. It must be filed with the SEC not later than 120 days after each fiscal year end. EDGAR is the SEC's electronic data gathering system. It's a software program, runs on the SEC's website. And so that's where it's filed. It also needs to be posted to the issuer's website. And so here again, just footnote that the information that is being posted about the company is going to be very public. So again, confidentiality, if that's important to an issuer, is simply not going to be available. The information in these annual reports is similar to the original offering statement that needs to be filed with the SEC and basically posted on the website of the platform. Though there's not a requirement that the financial information be audited or reviewed, unless, as earlier stated, that's a condition to the amount that is being raised in the offering. And if the offering is going to be made again or continues, then you're going to have that level of CPA involvement. Again, no general advertising. You can only describe, the issuer can only describe the terms of the offering, which is very basic information, in a notice that basically directs investors to the portal or a broker. I am anticipating that the portals will provide for some form of electronic communications between investors and issuers. The SEC's rule contemplates that may occur, and that is, in fact, how the wisdom of the crowd is, I think, going to be conveyed, because that is an important facet, in fact, rationale for the whole crowdfunding concept. There will be resale restrictions if you buy an investment on a crowdfunded platform. The holder, the investor, will have to hold it for a year. There are exceptions in the rule for resales to either the issuer, the issuer's family, or to accredited investors. And this becomes important because small investors may need money to pay for other expenses, and liquidity is going to be a concern. But they do need to understand they will have to hold it for a year, and that resale restrictions, and in fact there will not typically be a market for these, so resale will be very limited. There are bad actor disqualifications from the use of the crowdfunding exemption, and these are basically if there are regulatory violations that have occurred against or involving a controlling shareholder of the company or a director or an officer of the company. It precludes the use of this mechanism of crowdfunding to raise money. So that is, in effect, the federal rundown of the federal requirements. And as it's just brand spanking new, we're going to be waiting to see kind of how this plays out in the marketplace. And so I'd encourage people to visit the websites for the 8 funding portals that are shown in the prior slides, and see how they will make this work. So next up, as Rick mentioned, the other mechanism for crowdfunding that has been around for a while, it's been around since 2014, is intrastate crowdfunding. Michigan was among the first states to offer this. It's the Michigan Invest Locally exemption, which is where we get the MILE acronym for. And this, again, is based on an exemption from federal law and federal requirements that are under Rule 147, that is to say intrastate. And again, just to emphasize that currently the federal exemption is dependent on no offer or sale being made across state lines. And so it's important that these offers be controlled. And I'll say a little bit more about that as we go on. So basic requirements for the MILE Act in Michigan is that the issuer, the company, must be incorporated or organized in Michigan, and under the federal exemption has to use at least 80% of the proceeds from the offering in Michigan, and at least 80% of its operations be in Michigan. And then, of course, investors must be Michigan residents. A common question that comes up under this is, well, what about snowbirds who have a primary residence here in Michigan, but who travel out of state for the winter months? Importantly, you want to be able to establish that the investor has a primary residence in Michigan, The SEC's guidance has indicated that it is okay if an investor, temporarily leaves the state, but you want your communications to all be within Michigan, and so you would not want to send an offering document to someone in Florida. Rather, you'd send it to them at their Michigan address, and then it's up to them what they're going to do with it. But you want to be sure that it is a Michigan resident. In addition, the MILE Act has also limitations on the amount of money that can be raised in reliance on this exemption. And the first is up to $1 million in any 12-month period without, if you don't have, that is to say, without audited or reviewed financial statements to be delivered to the investor. And if you do have audited or reviewed financial statements, and those can be provided to the prospective investor, then you are permitted up to $2 million in any 12-month period to be raised. Similar to federal law, there's also a limit on the amount that can be sold to each investor. This is done a little differently. Here, the maximum investment per an unaccredited investor is $10,000. So this is not tied to an overall investor limitation for all investments. This is tied to the specific investment that is being made and allows unaccredited investors to invest up to $10,000 in an offering. And there is no limit for accredited investors, as Rick described earlier. The Michigan MILE exemption does not require that the offering be conducted through a website, though that really is largely, I think, the intention behind it because of the cost of doing so and the ability to reach a broader, though limited to Michigan, a broader audience than might otherwise be available. And both the issuer and the website office operator are required to file notices with the state of Michigan. Again, just to emphasize here, the federal intrastate exemption requires under Rule 147 that both offers and sales must be intrastate. And if the SEC may loosen this up, the proposed rule at the SEC level has been, comment periods have been closed, and I think we can anticipate that happening. But it is still, at this point, very important that both offers as well as sales be limited to Michigan residents. So it's important to note that an issuer cannot simply post a securities offering on its website. You need to be able to restrict access to the information. And this is commonly done on the Internet by having some kind of click-through screens that prevent the general public from viewing it, hence receiving an offer, by providing some attestation on the website or through the website of what is their primary address, maybe their driver's license, Michigan driver's license number, something along that line. And so the technology can be helpful in gathering this information and being able to evidence it in some manner. So today, even a single cross-border offer or sale is going to void the entire offering. It will void the federal exemption. So I cannot emphasize enough that this is very important to carefully control. And we're hoping that the pending SEC amendments will at least allow offers to be made anywhere, so long as the sales are restricted to Michigan residents. So just a little additional information here about the MILE offerings. The issuer must file a notice with the Michigan Department of Licensing and Regulatory Affairs, LARA. There's a $100 filing fee. There's prescribed information. I won't go through all the details here because it's laid out very clearly in Lara's materials that are available online, and the link is provided in later slides. Disclosure, always important in order to be able to satisfy the anti-fraud prohibitions. And the disclosure statement that is required to be filed and to be given to prospective investors includes, very much like the federal requirements, a description of the issuer, the business plan, history, and the like. The identity of owners. Here the threshold is down to 10% of the owners of the business, as well as the executive officers, directors, or managing members, terms and conditions of the offering, and a description of the percentage of ownership that the owners or that are available, being made available, the identity of individuals assisting the issuer and conducting the offering, description of any litigation involving the issuer or its management, and then the name and address of the website that's to be used. Also needs to include disclosures and legends that these securities are not registered with the SEC or any governmental agency, and that they are subject to restrictions on the transfer and resale. There are some other limitations as well that I'll leave to the audience to review separately. We've talked a little bit about investor requirements, that it must be Michigan. The offering period may not exceed 12 months. And if it is made through a website, there are some specific conditions that are listed here, that evidence being provided to the website operator that it's a Michigan company. The website operator must file notices with Lara as well. The operator is required to update information and maintain records that Lara is permitted to review. If the website portal or operator complies with these requirements, it is not registered or regulated as a broker-dealer or investment advisor, but it is not permitted to give investment advice or recommendations. Again, like the federal exemption, it's a display only and does not allow for solicitations or recommendations. Can't pay transaction-based compensation, and Lara is anticipated to be promulgating rules that may address some conduct standards. Here is a list of the intermediaries, website operators that have filed today. There are 10 of them that are available. The website, the link that is provided here, will take you to the list, and it includes not just the names but the addresses and contact information for them. Linda, if you're on, do you want to summarize what Lara's kind of experience has been to date with this?
Absolutely, I'm on. Yeah, the one thing that we have noticed is we haven't had a lot of people in the filings. If you go to the page where it shows the securities mile filings, we only have 14 that have actually filed with us since it became available in Michigan. So I guess we were hoping for a little bit more. I do think, and I don't know if you'll agree with me on this, Shane, I do think crowdfunding has been a real positive in that it has really made small businesses aware of the fact that there are other options out there for raising capital. I think it's done a great job of that. But we haven't actually had a lot of filings.
And I concur. I think it has demonstrated that when the offering is locally focused, and a number of microbreweries have utilized this, where the investor might also be a customer or might be a supplier. There's a connection there. People can walk down the street, kick the tires, shake hands with the owner, get comfortable with it. It's very much more of a local orientation, I think, has kind of been the history there.
Yeah, I would agree. I also think that people have thought about now raising capital using the state crowdfunding, but once they get into it and then they start exploring their other options, they realize maybe there's another option that's better. So I think it's been a great way to introduce.
Yeah, get people thinking about it. And it does provide, again, just another avenue for this. Just an observation here about the types of securities or investments that have been offered. I think the listed offerings that have been conducted to date, many of them have followed what I would characterize, and Rick mentioned, as a revenue sharing model rather than offering common stock, partly because if you offer common stock, the shareholders get a vote and they get to come to your annual meeting, and you may have to manage a small shareholder base. Whereas some of the other alternatives, revenue sharing has been an attractive business model where, for example, the company agrees to distribute, pick a number, but 7% of sales every month to all of the investors, perhaps limit it to a return of 150% of their initial investment. No guarantees. You know, if the company doesn't make money, there's not going to be returns. But it is different than debt, where there's no promise for the return of principal and no stated fixed rate of interest. So the helpful thing is that these are generally self-liquidating or limiting, don't involve voting rights, and so it is maybe a more attractive type of security to be offered and sold that allows for raising money but doesn't have some of the other downsides to them. Finally, I'd note Michigan investment markets is a concept that was enacted into law in Michigan in 2014. The concept here was basically to try to create liquidity or a secondary market for trading, because once you have investors, as I mentioned earlier, they may want their money back at some point, and the company may not have that available. And so as a result of that, oops, I went a little too fast. Let me go back. As a result of that, secondary trading may be important. It's not effective yet. I would note that it is a great concept. It has some bugs to be worked out of it. But with that, let me stop and turn the microphone over to Rick to talk about accredited crowdfunding, which is really a third method, and this is kind of a hybrid of these concepts. So, Rick, I'll turn it over to you.
Okay, thanks, Shane. Let's go through this real quickly here. We're coming up to the end of our time, but accredited investor crowdfunding is really a more descriptive name for it. Is technically a Rule 506 offering under Regulation D that we mentioned at the beginning of the program. And what's unique about a 506C offering, or what we call accredited investor crowdfunding, is that it permits general advertising and solicitation to find investors, just like in federal crowdfunding and in Michigan crowdfunding. But the big difference is the issuer may sell only to investors the issuer reasonably believes are accredited and with respect to whom it has taken reasonable steps to verify accredited investor status. But there's no intermediary required, and because accredited investor crowdfunding permits general advertising solicitation, this means that an issuer you can put an ad in the Wall Street Journal, you can solicit capital on your website or on your Facebook page, you can send out blast emails soliciting investors, you can appear at an investor conference and make a pitch for investors, or you can even run a billboard if you wanted to and put your stock on on there, all of which has been done under accredited investor crowdfunding, and you can't do those per se under either federal crowdfunding or state crowdfunding. And other than compliance with the anti-fraud regulations we mentioned earlier and the filing of Form D with the SEC, which is not complicated, there is really little else that a company would have to do to comply with this exemption. So whether you want to use, and I'd say it also allows companies to raise an unlimited amount of capital without compliance with state securities laws, which is another big advantage. So whether you would want to use accredited investor crowdfunding as opposed to these other routes depends on whether the benefit of being able to publicize your offering to the crowd in broad terms is greater than the burden of having to take these reasonable steps to verify accredited investor status of all your purchasers. So let's take a look here at what would constitute reasonable steps to verify. So according to the SEC's guidance on accredited investor crowdfunding, in order to make this determination, it has to be done objectively in light of all the facts and circumstances. So in other words, that's just another way to say there's very few bright lines to help us determine what may be reasonable for one investor over another, but we're told to consider at least three factors. First, the nature of the investor and the type of accredited investor that the investor claims to be. Second, the nature and amount of information the issuer has about the investor. And third, the nature of the offering and how the investor was solicited and whether there's a minimum investment amount. And these different factors will have a bearing on how much legwork will be necessary to verify accredited investor status. So, for example, if you put an ad in the Wall Street Journal and Warren Buffett responds, there's probably not a whole lot you have to do to verify his accredited investor status. But if you get contacted by some West Coast private equity firm that you don't know and haven't had any prior contact with, and you're probably going to need to do some additional and obtain additional background information. Sometimes if you impose really high minimum investment amounts that really couldn't be financed, that would likely reduce the need for additional steps, since it's unlikely that someone who wasn't an accredited investor could afford to make these higher minimum investments. And so those are some of the examples. Now, this slide provides some further information. Oops, went too far. There we go. So the SEC has provided a safe harbor for verifying accredited investor status. If you didn't want to go that facts and circumstances test on those three factors that we just talked about, then the SEC has given you these as deemed certain verification steps to be reasonable. And so you don't have to follow these steps. They're just available if you wanted to. But if you follow these steps, then you can be confident that you've taken reasonable steps to verify. The first one is that you review the investor's tax returns. The second one is that you review investors' bank statements or brokerage statements or credit reports. I mean, my guess is that most investors probably don't want to provide such financial information. And so it might limit the use of these first two safe harbors. The third one is the one that I think most companies would use, and this is where you are allowed to submit a written confirmation of accredited investor status from a licensed broker-dealer or investment advisor or a CPA or a licensed attorney. And note that just filling out a subscription agreement or investment questionnaire that you may be familiar with in the past, that is not by itself a reasonable step to verify. So these check-the-box questionnaires, which you've probably seen in traditional private placements where you just check a box to say, yes, I'm an accredited investor, those are not sufficient to verify accredited investor status. So you would have to do one of these other routes to do that. So here on slide 21 and then on the next slide, we sort of compare these three different types of investment crowdfunding that we've been talking about today. So as you can see, depending on the circumstances of the client, I would think in most circumstances where the client has exhausted, let's say, friends and family, angel investors, and any traditional private placement investors to which they may have access. And if the client has decided to go beyond those traditional sources and seek investors from the crowd, then accredited investor crowdfunding really provides the most flexibility. And at least until now that federal crowdfunding is available, it's really been this accredited investor crowdfunding that you've been reading most about and that you've seen online. Now, the only limitation of accredited investor crowdfunding versus federal or Michigan crowdfunding that we mentioned is that you have to be an accredited investor. But I think in most cases, a company would rather have an accredited investor rather than non-accredited investors. And as Shane has pointed out, I think you'd rather have fewer, more sophisticated and larger investors than a lot of small investors simply because of the administrative burden of trying to communicate with lots of little investors. And this is not to say that federal crowdfunding or Michigan crowdfunding would not be helpful in certain circumstances. But again, in most cases, I would think a company would not use federal or Michigan crowdfunding over accredited investor crowdfunding if they're willing to live with just having accredited investors in the company. So let's briefly go down this chart real quickly. First thing to note is that accredited investors crowdfunding provides the broadest crowdfunding reach and the easiest investor access to information on the company. Federal crowdfunding, as Shane explained, requires that all inquiries go through an intermediary, which then has to meet those investor protection requirements he talked about. And you can't put the same information on your website, for example. Michigan crowdfunding, as we talked about, is limited to Michigan residents only. And at least right now, if you're using a website, then you've got to filter through those having access to the website in order to make sure you're not offering to persons outside of Michigan. Second, accredited investor crowdfunding has no limit on the amount a company can raise and no limit on the individual investor can invest. So again, more flexibility, less administrative work, monitoring investments. And as we talked about, having a large number of unsophisticated, non-accredited investors can increase administrative costs, communication issues, and shareholder relations issues, and also increase risks of litigation if the business is not successful. And I think most people would prefer to have persons that understand their business and understand investing and might know their industry would be the preferable kinds of investors that you would like. This total amount, the limit on the total amount of the offering for federal and Michigan crowdfunding is really a major limitations. I mean, smaller startups can live with the smaller investment limits, but for a lot of other companies, it might not be that practical. And then the other issue is that accredited investor crowdfunding has no mandated disclosures or filings other than a Form D, and it has no post-offering reporting requirements. And now, this is not to say that there wouldn't be some sort of disclosure for accredited investor crowdfunding, and in some cases it might be every bit as much information and maybe even more than you might have for a Michigan or a federal crowdfunding offering. But the point is that you have lots of flexibility to tailor the disclosure to the circumstances of the offering, and you might choose to have more or you might choose to have less disclosure. It just depends on the circumstances. And so also accredited investor crowdfunding is more flexible from a timing standpoint because you don't have to wait for any mandatory filing periods like you do for federal or state before commencing the offering. And finally, I suspect that accredited investor crowdfunding is likely to be less costly simply because there's fewer regulatory issues that you have to deal with. So in my personal view, in most circumstances, if you're going to seek investors from the crowd, I would think that accredited investor crowdfunding you'd look to it first before you look to either federal crowdfunding or Michigan crowdfunding. But that's just my opinion, and so I don't know, Shane, if you had any different views on that or any other comments.
Yeah, I'd agree with you, Rick. It really depends on your business objectives. If you're small and going to stay small, the Michigan crowdfunding or federal crowdfunding may at least appear to be cheaper and simpler in that the mechanism for it at least seems simple. The concern becomes, though, if you really intend to grow and need future investors, it becomes more problematic for subsequent investors if you have a lot of little investors that have to be factored into future securities offerings. And I would add, as I mentioned, that getting good advice about structuring the business and its ownership is important, because if you start off on the wrong foot, you may find yourself having to deal with other legal issues that really go beyond the securities offering. So I concur that in terms of limiting the number of investors and having more control over the process, and I think importantly, being able to decide who is your owner among your owners and investors, which you can do with accredited investor crowdfunding, is more important, because you can control the process more closely.
Okay, Shane, did you want to cover these resources that you had on this slide?
Yep. I will just say that the slide here has links to several important releases and information. The first several from the SEC. The first one is a guide to issuers about federal crowdfunding. It explains the process in a bit more detail. The SEC has come out with a couple of FAQs that are in their compliance and disclosure interpretations. And I'd encourage the audience to think about their offering of securities from the perspective of an investor, because at the end of the day, the wisdom of the crowd may turn out to be the whim of the crowd, and so you need to be thinking about what those investors are looking for, and some guidance the SEC has given to investors about crowdfunding. So I think that's helpful to understand. And then there's information there from the SEC and FINRA about crowdfunding portals. And then as to Michigan, Laura, the Michigan Department of Licensing and Regulatory Affairs, our host for today, has some really excellent FAQs and information that are listed there. And so I'd encourage the audience to read those materials. This is simply a chart, really nice chart that Lara has put together. Compares different types of offerings, and it's small print, so I'll leave it to the audience to review it. This is also on Lara's website, and so they can click around and see that on that website. So there you have it. Rick, if you don't have any more comments, we'll kick it back to Linda and see if she's got some questions.
We actually don't have any questions. I mean, it was so thorough, I don't really know what they could ask. It was an excellent presentation. I am so thankful. I will do a quick sign-off, so hold on for another second just in case someone puts one in. But I do want to thank everyone for joining the last of our 6 Lunch and Learn webinars. We hope you all enjoyed it. We want to thank Mr. Hansen and Mr. McDonald for taking time out of their busy schedules to share some very important information with us. I do want to remind everybody that a recorded version of this webinar will be available for viewing in the very near future at www.michigan.gov/securities. And one last reminder that our next upcoming live seminar will be in Marquette on June 23rd if you would like to sign up. The seminar is free and breakfast and lunch are included. We have no questions, so I just once again want to say thank you for joining us, and thank you to the presenters one more time, and everyone have a nice day. Thank you.